is also held to say she does not want us to vote on this yet, but she does want us to, she wants me to give her an update on where the subcommittee may be on this. So is there, hello there, Delegate Pungalo. Okay. Is there anybody who has any new thoughts or feelings about House Bill 392, which is the carving out of the two-party consent on housing, conversations about housing? Do we have any new feelings, thoughts? What I'll suggest is that if there is any strong feelings one way or the other, please talk to me individually if you want to. But yeah. Oh, wait. Holly, are we actually officially on?
We're not. Are we live? We're live now.
You're live. Okay. Then for the record, this is the Civil Law Procedures Subcommittee of the Judiciary Committee. It is 2:28 at a little after 2:00 p.m. Okay, Delegate Schmidt, did you have something you wanted to say, or you didn't on 392?
Yes. I mean, we've talked about this many times. We talked about it last week. I talked about my concerns regarding the ulterior motives of the nonprofits or the motivation of the nonprofits, and it still continues to be a concern for me here. And just want to get that on record, just to share that.
I will let you know that there are folks on who, if we had questions or concerns about training or about inappropriateness of letting this get out of the hands of law enforcement, they are happy to chime in.
And Chair Cardin, Kara's working the Zoom. She said just let her know if there's somebody you want, and she can let us know if they're in the waiting room.
So I think that the MMHA person may be in the waiting room. I mean, I'm planning on spending just a few more minutes. It doesn't seem like I would ask that people put a little bit of thought into it when your drive home or drive back over the weekend. Just think about this.
Mr. Chair.
Yes.
I just want to reiterate, I can't remember if we had this discussion. I might have been not chiming in on the last subcommittee about this, but I continue to think if we are stepping into the world to breach two-party consent for this purpose, it would be nice, again, if we could do something that's comparable to going before a judge to get a warrant, where you have to meet some threshold that indicates some intrusion like this is warranted. And again, the other issue I had flagged was whether this might be more, again, just to get something going, more easily suited to a scenario where it's an institutional player in some way, or someone where the harm is more likely to replicate, in other words, multifamily or multi-unit ownership of some sort. And that's my only thoughts. Again, just thinking about all of the skepticism that we're hearing from some folks, if there's a way to go forward on this.
I will. There was one other thing that you had mentioned last time we spoke, which I'll just bring up to the group, which is that there are a couple of two-party consent carve-outs that there's one or two in law now. They're very, very narrow, but there are others that are seeking it. And to rank this higher than perhaps something dealing with children or domestic violence in terms of the criminal world is just an interesting conversation on whether that's appropriate. So I think you and I had spoken about briefly, just more from a theoretical standpoint, not specific amendments, but okay. Anybody else have a comment about 392? Yes, Delegate Kramer.
Yeah, I had to go to the bathroom. I stepped in late. It sounds like we're going to ponder this one over the weekend.
Yeah, we're not doing anything this week. I just wanted to see if anybody had additional thoughts. We spoke about whether some sort of warrant procedure is appropriate, whether this should be ranked as high as it is in terms of other groups that are looking for one-party consent. I had mentioned whether training is appropriate and whether it should be specified in any legislation. And then Delegate Moon had talked about the institutions where this would maybe be appropriate or be narrowed to as a starting point. And that's
Yep.
those are just some thoughts.
I know Delegate Archon had an amendment on this that came through the email today, but I would generally express the same concerns that Delegate Moon has. I'd rather we have a process for kind of having a check and balance to say, well, yeah, we delegate you the authority to have some kind of recording. This is a little bit of an awkward situation as it's not, we don't have a warrant process where we're empowering law enforcement to say, yeah, we're going to allow you to use a stingray for this person. This is kind of like an exception. So I don't know how we would create an exception to the wiretap law with a maybe a process in front of a judge. But I do think more broadly that's the better thing to do than start just chopping up the wiretap statute.
Great. Well, definitely if Erican has an amendment that she's considering, maybe work with her on what you've got as well. That's fine. But certainly talk to the vice chair about it as well. Okay. Yeah, we're gonna be we're gonna look at 3 other bills. I'm not expecting this to be a very long subcommittee meeting for somebody texting me about how long we think this is gonna go. Okay. Okay, let's Claire, thank you very much for being here. If you want to stay, you're welcome to. Or if you need to prepare for the criminal. Okay. Let's go. Do we want to take the heavy stuff first and talk about, no, you want to take the easy stuff first? Okay.
You want to do House Bill 660?
Let's talk about House Bill 660. Okay. I am pulling up I didn't print this out. It went out for me. Okay. So this bill was brought by the Register of Wills. It's Delegate Terras's bill. It allows for the petition for administration of a copy of a will to be filed with the Register of Wills instead of the Orphans Court. The bill authorizes the Register of Wills to admit a copy of the will for administrative probate without needing authorization from the Orphans Court. Or it can go into judicial probate, meaning they can send it to the Orphans Court. So basically, the administration of the will can happen without it being reviewed by a member of the Orphans Court, or in the jurisdictions where the Orphans Court's handled by the Circuit Court, it has to be reviewed by the Circuit Court before it can go into administration. And this would forego that for certain wills. You will note that the judiciary is not in favor of this, and the Orphans Court Association is not in favor of this. My biggest concern is the judiciary. The judiciary states that the legislation amends 5802 of the Estates and Trusts article to authorize interested person right. The judiciary opposes this bill as it circumvents the authority of the Orphans Court. Even in cases where there is consent, it would be inappropriate to remove jurisdiction from the Orphans Court, as there are statutory factors that require a judicial determination as to what constitutes a will that should be admitted into probate. The proposed bill inappropriately confers judicial authority onto the Register of Wills. Now, I will say that I did have a conversation with Byron McFarland yesterday, and he indicated that they are incorrect about that. So, but that being said, I'm gonna open it up for discussion. We believe we have Mr. McFarland in the waiting room and he can be let in. Is there anybody from the Orphans Court
If so, Kara, it would be Judge Yates.
or, yeah, Judge Yates or somebody from the judiciary? So.
Delegate Carden, can you hear me?
I can now. We have
Okay,
Mr.
thank you.
McFarland in the waiting room and he can be let in. But who has their, I guess that's,
That's me. I'll take it down.
okay. All right. Delegate Phillips, did you have a comment?
No, I'll take it down. Though I do have a question about numbers, right? In today's environment, from a technology perspective, it's almost impossible to figure out a copy from a original. But the question I have is about numbers, and maybe someone either from the Orphans Court or the Registrar's office could tell us how big of a challenge this is.
Mr. McFarland, do you want to?
Yeah, I think it's a great question, and I appreciate everyone's time today. Thank you so much, Delegate Carden, for talking a little bit about this yesterday. We have seen, Delegate Phillips, the number of copies being admitted to probate grow consistently over time. And included in my written testimony to the committee, it's just grown consistently pretty much every year, and we expect that to continue. And so what that means is that, even though we have a valid copy of a will, so it's signed with two witnesses. We have no question that it's a valid will, and we have a petition and we have consents from everyone who could conceivably have any interest in the estate. We're left with the fact that our orphans courts, and I want to be clear, the purpose of this bill is not that the orphans courts are not doing their job or they're making mistakes. It's the fact that they are part-time. It's a systemic issue. And even in your county, Delegate Phillips, even in a large county like yours, there is not an orphans court available most of the time. In some jurisdictions, an orphans court may only meet for an hour a month. And so we have families, even though we have a valid copy of a will, we have a petition and consents from everyone, they're basically ready to go. They've done everything they're supposed to, and they are waiting on a court to be in session just to proceed with opening an estate. And simply as a matter of efficiency, the registers are the ones we're sitting there telling families, basically, you have to wait. And they say, well, we're all sitting here in agreement. We're ready to go. What's the problem? And it's that the law does not allow us to probate that. Unlike most wills, I want to clarify that 94%, and this is why the testimony of the judiciary is, as a matter of law, just inaccurate. 94% of wills are probated administratively by the registers of wills. It's only a small minority, 4%, that go through this process where there's a copy, a petition from an interested person, and consents from everyone. And then it's only 2% that go through judicial probate, and that's a process where there is some kind of conflict and the family has to appear before an orphans court, and everyone has an opportunity to kind of have their say over whether the will is valid. And so with that, we simply see this growing number of copies. As long as everyone is in agreement, it's essentially a settlement agreement, and that was my testimony. And so, why are we waiting? We have a part-time orphans court system, whereas the registers are full-time. We're just asking, why don't we just allow us to probate these just like we do original wills? And the last thing I'll note is that the last full year we did a study of, an in-depth document by document study of this was in 2022. There were 433 copies of wills that went through this process, and 100% of them were approved by the orphans courts. So if it's just a matter of a signature, let's make this process more efficient for people.
Got it. So 100% in 2022, after it went through judicial review,
That's
they were
correct.
all found to be valid?
That's correct.
Wow.
Every single one of them. Yes.
All right.
I will note for the record that the Association of Orphans Courts have 5 reasons why they oppose this. I'll just mention 2: potential disputes and lack of safeguards. lack of adequate safeguards for errors and legalities and unintended consequences. Specifically that the bill may unintentionally encourage the use of incomplete or questionable will copies in probate proceedings. Without the oversight of the Orphans Court, the potential for errors in the probate process may increase. So, yeah, I don't, and tell me, so I actually have a question. Let me just wait. Let me just reduce this down so I can see. Does anybody else have any questions before I ask? Some quick question, Mr. McFarland. You're saying that these part-time, so if you're a full-time orphans court, if there's orphans court that is sitting at least once a week, the maximum you have to wait would be like 5 days, right? Or is that not true?
So there's only one full-time orphans court in the state, and that's Baltimore City. The rest of the courts sit at least, maybe only part of a day or part of a few days, or maybe only part of one day a week or every other week or every couple of weeks. When we did this survey and we did a detailed study, the average wait was 2 weeks. Now, what we also saw was that an awful lot of them, a lot of these petitions would wait a month. We found one case in Prince George's County where a petition sat for 28 weeks, 28 weeks just to get a signature from a court. And I think that that's really unjust. And what we've also seen is that, because more people are using copies, more people have to wait. And we've also seen, we actually did a study in Baltimore County specifically between 2018 and 2024, the average waiting time went from 1 day to a week. So I'm not sure why that is, but just because a court is sitting doesn't mean they're going to get through all of the cases that are waiting for them. And the last thing I want to note is that, I really do find it a little odd that the courts have decided to weigh in on this, because they have, as of right now today, they have at least 50 of these petitions pending in front of them right now. So I'm not exactly sure why judges are weighing in on statutes that they have to apply to cases that are pending before them right now. That just seems a little unusual to me.
Mhm. Well, okay. All right. I will say, and without, well, we thank you. Is there anybody, any have more questions for Mr. McFarland? Okay. Thank you very much. We really appreciate it. Okay.
Thank you, Delegate.
Yep. And it sounds like we do not have anybody here from the Orphans Court. So, I will express my opinions, and does anybody else have anything else they want to say? All right. All right. Mr. McFarland, you're good to go. All right. So, and you can listen in, I guess, through the general thing, so you can see how we go. All right. I'm happy to put this out for a motion. I personally think I'm not trying to be, I'll be persuasive, but I don't want to force anybody's hand, but I just think that why can't they figure out a way to work with the judiciary to get the judiciary on board? To me, it seems like that would be, I'm not exactly sure if what they're saying is true, then they should sit down and they should talk it out and figure out a way to make it more efficient and easier. I don't know why this has to be about contention between the two, in my humble opinion. So I would not be supporting this, not because I don't love my Register of Wills, who is fantastic in Baltimore County, and who I want to help make it more efficient. I just don't understand why this has to be about the courts versus the Registers of Wills. That would be my comments. Delegate Conway.
Move for the unfavorable.
Okay. Should we give before we do that, we don't have a second yet, so we'll wait, but the motion is for an unfavorable. Let's see, Delegate Embry. Yeah.
Sorry, took so long. I share your concern about why they can't work together, but I do think this bill would help resolve these matters more quickly, which I think is good for Marylanders seeking probate. So I am I am supportive, but I do share your concerns. And so if you want to
What, I
put
mean,
it off to hear more from the courts, I'm fine with that, of course.
did they come in with this bill last year? They didn't come in with this last year, right?
It
So
was
this is-
last introduced in 2016. And that bill was withdrawn.
And that bill was withdrawn. Okay.
Chair, I
Um,
apologize. Was this 623 or 660?
660.
Thank you.
Yep.
That's my question.
Okay. I am not.
Mr. Chair,
Go ahead. Yes.
if I may, I actually share your concern about wishing the judiciary either misunderstanding or concern would be addressed, but I'm actually also likewise inclined towards Delegate Embry's position, and so would be inclined towards a favorable and against the unfavorable at the moment.
Okay.
So
Well-
I will share my perspective if I could.
Sure.
I think, John, you may do a little bit of estates and trust. I do a little bit of estates and trust. What I'm finding is individuals frequently, the only thing they have is a copy of a will. They find it, they bring it to me, and I say, I'm glad you brought me the copy. If it wasn't filed with the Register of Wills, we've got to go to judicial probate. And it can be a challenge. So from, as a practicing attorney, once again, I'm not saying I'm an expert and I don't do hundreds. It is inconvenient. It is inconvenient. And the numbers that he just gave me in 2022, 400 plus, and not one was rejected.
I would assume that's Howard County, though. That's not the state. Is that statewide or is that?
I think it's probably statewide. I think that was
Statewide?
statewide. And actually, in the scheme of things, I forget how many estates are opened every year, but I'm surprised that they're not more. Because often people just don't, they don't have the originals. So is it potential for fraud? Absolutely. There's always a potential for fraud if we opt out. Last year, we passed a bill which none of the courts have really embraced, which gave them the ability to take everything except for the will as a copy, if you recall, and to accept electronic filings. To the best of my knowledge, none of the courts, none of the orphans courts or the registers have accepted that or actually implemented that. So we gave them, I really wish we could give them required language. I think we made it in May.
Was that the orphans courts or was that also the registers of wills?
I believe it was it was both.
Right.
Right. So, I mean, we're living in a different time. And in my mind, I think we need to open it up and make it simpler. So that's my thoughts.
Okay. Delegate Conaway, did you have something else to say or your hand's still up?
Yeah, I withdraw my motion. Thank you.
All right. All right. Would anybody be upset? Yes, Delegate Grammer.
Yeah, I just want to say I'm still a little uncomfortable with the bill. If we took a vote, I'd probably vote no, but maybe we could hold it a week and we could all make some calls. This is a very technical thing. I don't think anybody's really worked up, especially about the Register of Wills and how they work technically. But I mean, do we need a week so we can all make calls? Maybe we need to amend this so we can
Well,
clarify.
I was going to suggest that maybe we can reach out to whether it be the orphans court or the judiciary itself. I will reach out to the judiciary, but if you want to reach out to your orphans court judges, that if anybody knows any of them or has relationships, and say, is there a way that, because right now it looks like this is going to go. Do you want to figure out a way? I think the yays may have the votes on this, although I'm not going to whip it because I don't want to know for sure.
No.
But if you want to tell your orphans court judges this may pass, you may want to figure out a way to work together. And if there's an amendment that may be appropriate or something else, that may be the way to do it. And I will tell you, I do not believe that Terrace's bill is cross-filed. I could be wrong about that.
No, it's not.
So I think that she wants to make sure it gets out before crossover if it's getting out. So just kind of giving everybody a heads up. But I think that's what what we'll do. And I appreciate the withdrawal of the motion of Delegate Conaway.
And I will reach out to ours, John.
Yep. I
I'm
mean,
gonna
I
reach out
have.
to I'm gonna reach out to the newest judge because she's less tainted.
Well,
I didn't say that. I didn't say that. That's not true.
I love our orphans court judges. I just, once I get them on the phone, I can never get them off the phone. So,
I know. So, okay.
Okay, great. Okay, we got rid of the easy one. All right,
That was easy.
let's talk about let's talk about Delegate Foley's real fast. I don't think, we're not going to vote on Delegate Foley's, and I'll tell you why. So this is House Bill 74. This is and this is also not cross-filed, I believe. So if we're going to do something, we need to do it relatively soon. But the amendment that was offered last week that you remember, it created an and instead of an or in terms of digital and printed publications. And I went to the Publishing Association and said, I think this is a windfall for you, and it concerns me that we're actually turning it from something that is a little bit more efficient to even something that's even more onerous on people that have to publish. Their comment was they didn't think that's the way, as the bill was written, that's actually not true. And there's the whole second section, which gives an out. So they may be on here. I don't know if they're on or if not.
Are you
But
asking for Rebecca and Lorenzo or no?
if Lorenzo's on, you can feel free to bring him in. I'm not going to try and hide the ball here. Okay. The question, I had asked Rebecca, and Lorenzo was sitting right there, for some specific language or some specific written information as to why they believe either a better crafted amendment or why they believe the and doesn't enrich them in a way that can be onerous on people who have to publish. And I haven't gotten anything yet. So I was going to hold this for a few days more to see if they were going to be able to provide us anything. Lorenzo, you can take yourself off of mute. Are you going to get us something so that we can discuss it? Because if not, we're going to move the bill as originally drafted. Just
please hold the bill. I believe Rebecca is on as well. I don't know if Holly can let her in, but
Yeah,
we will get you that information. I thought we had gotten that to you. We had a conversation with you about it the other day.
right.
But absolutely can get you that information and can clarify your concerns about that.
Sure. And if you did get it to me and I just haven't seen it yet, I apologize, but I'm happy to hold the bill a little bit longer till the next subcommittee meeting. Rebecca, did you have anything you wanted to specifically say about it while you have everybody on the phone? We've got another 4 minutes on this bill, so go for it.
Yes, so, and I'll resend it. Maybe the email didn't go through. I sent something on Tuesday about this on the amendment. What we want to make sure, we don't think it's a windfall. It's not intended to be a windfall. It's meant to just start the clock with the digital version of the publication. But it's important to us that it is both print and digital, because we do believe in the primacy of print, and we want to preserve that. So if you all are diametrically opposed to replacing it with and, we could put, we could put a clarifying clause that, it won't be only digital unless, I think it's subsection 2(3) is invoked. So I'm sorry that didn't reach you in time for this, and I'm happy to send it to the committee or work with Holly, whatever way you would like.
So yeah, if you can send it to me, copy Holly.
My payment for it that's coming up won't
Delegate
go through.
Conaway, put yourself on mute. We'll make sure, Holly and I will make sure that the whole committee, the subcommittee gets it so that we can discuss. Yes, Delegate Williams, I may have a question for you.
Yes, I just want to make sure I understand. So, is there going to be an amendment being proposed to change? And I guess I'm looking on page 2, line 18, to change the or to an and? Is that what's on the table?
Yeah, so I mean, I don't know what's on the table per se, but I know the amendment that we're proffering is in line 16 and in 18, it shows up twice. And we just really wanted to clarify. So that or would change to an and in print or digital. And then if you know, we believe, in good faith, we believe this is not a expansion of notice in any way. It is really more of a flexibility in format. I do have language that you all could choose to say, you know, if just to make sure that it's staying in print or digital until there isn't a print version in a jurisdiction, and then it could go digitally only.
So you're trying to narrow the bill so that it would be digital only in a place that does not have a paper.
That's written into the bill already. When Delegate Foley imagined the bill, it did have sort of a runway to say if there isn't a print and digital, because everybody has a website and they use it substantially. But if in some, and there is no jurisdiction in Maryland that does not have a print publication at this time, but if that would happen, then there is a pathway to go digitally only.
So I will express my one concern that I expressed to you. I'll do it publicly with everybody else, is that if you have and your comment to me was, well, there's always a plan that it always includes digital if you're putting it in the print, so there won't be a problem. But if we're requiring both, then these entities that are the publishers are going to create a new plan knowing that they're required to do both, and there could be new pricing that's set up because they now know that they have to do both. And that's where my concern was. I as somebody who wants to see our print media continue to thrive or at least live in the state of Maryland. So I want to help you, but I don't want to make it do on the backs of people who right now are just required to do one or the other. It seems like they're going to be required to do both. That would be my.
I get that. I think if that's not workable, then the alternative language that I'm going to send you as well might be appropriate. I'm sorry, did I speak out of turn?
No, that's fine. That's exactly right.
And Delegate Carter, if I may, just, and I know we talked about the issue of a blended rate, and I know your concern is that, you know, the papers would be getting both money from the print and money from digital. And I think we were trying to explain to you that, you know, that it is a blended rate that includes print and digital. So you wouldn't be putting like a surcharge on digital or surcharge on print and have like the overall fee rise or be increased because you're doing both. And so I know that Rebecca and others are trying to get that information to you. Obviously, you know, we can't share, you know, for antitrust reasons, I'm sure you understand, we can't share all the pricing, but we want to try to get you information to show that there is not going to be like double dipping, I think is what you had some concerns about.
Yep. Delegate Tolles, thank you very much, Brenda.
Yeah. Thank you.
Thank you, Mr. Chair. And so I think the last comment was it by Ms. Snyder that said they can do either or. I thought that the online version is this the same notice? This is legal notice. I know we got a couple bills that do the same thing. So could you just explain your last comment that is one or the other? I thought, and I could be mixing my bills, so I apologize in advance, but I thought that you can do that one of the bills for online. Wait, come back to me. Let me just make sure I'm not mixing my bills up. I know we're on 74, but I know that there
lines 16 and 18 say in the original drafting of the bill, it says print or digital format, print or digital. And right. What Ms. Snyder had suggested is it should say print and digital, and she does not believe that requires both, but rather it just requires one or the other, but it's a better way of saying it. And that
so the current law is both, correct?
No, it's just in print, actually.
Right.
Current law is just
some jurisdictions have online.
Well, everybody has print, so
I'm saying something, no, I know that.
Okay.
That wasn't my question. My question was everyone has online version.
yes,
So, right, because I think you all said that you went online to put this information online. So is that correct? Everyone has online.
correct. Everyone has online. The Press Association has an aggregated site that brings it all together in one spot.
Right.
So yeah, it is.
So
It
that's
is.
and then and that's the current law is that everyone has print and then as well as the online version.
That's not in statute. The
No,
statute.
no, I'm saying currently that's what's happening. It's not in
But-
statute. Okay.
But practice, you're right. Current practice is.
Right. Yes.
Right.
And your amendment, or was your amendment that you were attempting was to try to put it in statute to say print and. Okay. Thank
Right. This is for
Okay.
government notices. Yes.
Right.
We're gonna hold this till the next time we meet. We'll get some information from you, maybe hopefully some language. We will share it with everybody. One last comment, Delegate Grammer, did you want to have one last comment or not? And then we're gonna move on.
No, thank you.
Okay, great. Now let's move on to 623. Rebecca and Lorenzo, if you want to stay on, you're more than welcome to. All right. And I know we have Mr. McFarland on as well, so thank you. Okay, now, this is Delegate Embry's bill. Delegate Embry, do you want to say what the bill does again? And there was an amendment that you drafted that you shared with everybody. Do you want to discuss the amendment, or you want to let Holly discuss the amendment? And you can tell us whether you favor the amendment or not.
Thank you. So everyone, I know you've heard from me a lot, so I apologize. I'll be brief. This bill applies to one of almost 200 places in Maryland Code where notice is required in print newspaper. This is one of the places, one of the very, very few places that falls on individual Marylanders who are going through probate. It has two targets, heirs and creditors, not the general community. And those persons are now reached effectively, or can be reached effectively, through a centralized website created by the registrars. Delegate Grammer asked an excellent question last time. He said, how many times has someone called who was not already notified and known by the registers based on this notice? And Mr. McFarland said, no, 0 times. They've come back for years. So I think from a perspective of saving our constituents, our taxpayers, money that they shouldn't have to pay, and from an efficiency standpoint, and also saving the time and effort of the registers of wills correcting and working on these notices in paper versus controlling it on a website, I would urge you to move the bill as is. That being said, Delegate Cardin was looking for different options because there are real world financial consequences to papers, which I do respect and wish that was not the case. And so not with Mr. McFarland's help, Mr. McFarland's idea was that we could limit the impact by applying it only. So the bill would allow the use of the website for those estates where there's a known defined heirs. So the spouse, child, parents, I think, and I'm sorry, I don't have it in front of me, but, and Holly can describe it better, but that's an option also if the committee would prefer something that's sort of more of a compromise. Thank you.
All right. Great. So, and we do have the amendment that was distributed. I will make one note, and while I'm not a paid member of the Publication Association, I do have personally, I have sympathy for them, because this is a bottom line issue. I got calls from a number of different outlets that say that even though this is one of 200 reporting, this is the big one. This is the one that that really does drive a lot of revenue to, and it's in code right now required to these publication folks. So I do have some sympathy for them because I do think it's going to hit their bottom line pretty hard. I will go ahead, Delegate Hurricane. Yeah.
Thank you, Mr. Chair. Yeah, I've heard first from some of the newspapers about this. I just want to go on the record and say, I just do not believe that it is the role of government to keep things on the books that are ineffective just because of the impact on private industry. I don't think that's a reasonable expectation that the public has of our actual role. While I respect that, it's tough. Owning a business is tough. As a business owner, I know that. I just strongly do not feel that it is the role of government to ensure that private businesses maintain their revenues. Business models have to change. They have to move with the times, just like everybody else. So I felt the need to say that.
Yep. No, I personally, I happen to think that that's a very, very reasonable perspective. The reason I asked for the amendment to be drafted, I don't know if it was drafted in my name or drafted in your name, Delegate.
In my name.
Yes. The reason I asked for the amendment to be drafted is because while this would be a pretty big switch, and I thought that there could be both a compromise that might have an impact financially, but also it sort of starts the ball rolling. Those of you who have seen me in years past, I tend to believe in incremental movement as a way of trying to figure out if we're doing the right thing. And I thought that that would be an appropriate way of going. It would also get me to vote in favor of the legislation. So, if that's important, I don't know whether it is or isn't. Maybe the votes are there, but so I would like to move the amendment and just see if anybody else believes the amendment. Why don't we have Mr. McFarland explain the amendment? Thank you.
Thank you, Delegate Cardin. I just want to briefly agree with everything that Delegate Erican said. I just, again, very briefly, the argument that by not having these notices somehow there is no alternative for the papers just isn't accurate. They all have marketing departments, they all have ad departments, they can make up for this revenue. So I just want to say that. But as far as the amendment goes, I think what is fundamentally extraordinarily unfair about this requirement, number one, as Delegate Embry has said multiple times, a family has no choice. Unlike the rest of the notice requirements in statute in Maryland, you have no choice. You have a loved one who dies, they have probate assets. You have no choice but to do this. You have no control over the increasingly monopolistic choices that you have over the papers in your jurisdiction, and the papers can charge whatever they want. In Talbot County, it's over $300 for a notice. So given that, the amendment would restrict the actual print notices just to families where the heirs are more distant, so that you will not have a circumstance where, for example, if I died and I have a surviving spouse and no children, and I leave my entire estate to my surviving spouse, under current law, my surviving spouse has to go and publish notice in a newspaper to advertise for themselves. I don't know anyone who can possibly say that that's reasonable. And so with that, the amendment would exclude estates where the heirs are limited to a surviving spouse, a surviving registered domestic partner, or lineal ancestors or descendants. So if you die and the entirety of your heirs are limited to a spouse or a registered partner, children, grandchildren, parents, or grandparents, those are families where we know we're reaching everyone. There is no question that we're getting everyone that we're supposed to be getting with notices that we are, again, mailing to people, in addition to the notice on our website, which is in addition to the notice in a print newspaper that we know that, frankly, no one reads, not the legal notices section anyway. So with all of that, we thought that this would actually be very easy for us to administer, because we have to make decisions every day, whether a newspaper or whether an estate requires a bond, whether it has to go before a court, whether we have all the heirs, and whether it has to publish. We have to make all those decisions anyway. This would be very easy for us to administer. But again, I'm going to
To be
agree.
clear though, you prefer not to have the amendment. You prefer to have it straight, but you can operate with the amendment, and it would reduce the number of publications by about half. Is that
That's
correct?
correct. And if I could just quickly note, there are some additional problems that if you adopt the amendment, we still have three huge problems, which is that some newspapers require families to pay for these notices out of pocket before they even have access to estate funds, which I think is fundamentally unfair. Some of the newspapers require the registers, that is all of us paying through as taxpayers, require us to facilitate payment for their notices. We have to play the role of bill collector for them. And lastly, we will still have to do what we do now, which is every single day in at least one registrar's office somewhere in Maryland, we are all paying for people, us, to do copy editing for the newspapers. And I want to note, it's not the Daily Record, but it's some of the smaller papers where there are chronic every week spelling errors, information is incorrect, and we have to essentially do their job for them. So, the amendment I think is still fairly generous to the industry because we're still
because all those problems that now exist, you're still going to have to deal with the ones that have to go to print.
And that's thousands of work hours every year by our staff.
All right. We've got 5 minutes to go on this. So yeah, delegate, Lorenzo, yes.
Delegate, maybe one day, I don't know. But thank you, Mr. Chair. So with all due respect to Mr. McFarland, I just need to state this for the record. We have been, and I represent the Daily Record, we have been meeting with the Register of Wills since basically the bill was vetoed last year. Over the summer, I know that Mr. McFarland and I tried to meet with Suzanne and Rebecca at MACO, and that didn't happen. And so here we are, second time dealing with this bill in subcommittee, and now we have this amendment that's been suggested and proposed. I mean, I'm trying to read the room here, and so what I'd like to suggest, Mr. Chairman, is you hold this and give us a chance to, one, physically look at the amendment, unless you want to send it through the chat or email it to us. Let us have a chance with Rebecca and her members and my client have a chance to really dissect it and actually determine what the actual impact is going to be, and then get back to you with our position. I can tell you that right now, on its face, and just from the comments that are being made, and from the situation and the impact it would have, not just to the Daily Record, but to the members of the press that Rebecca represents, it is a significant financial impact, notwithstanding what Delegate Erican said, and I can appreciate her comments as well. So I just would ask that you hold this just like you held the other one. Give us a chance to review the amendment. It's a simple amendment, I understand that, but I still think the devil's in the details, and so I'd like to check that out, and then also have a chance to confer with my client and Rebecca to confer with her members.
All right, I'm going to hear from Delegate Grammer, and we only have a couple more minutes, but I think the amendment's pretty simple. So
it's the impact. It's the impact, Mr. Chair. That's what we need to.
I understand. Okay, Delegate Grammer.
Thank you, Mr. Chair. Just for the record, I hate the amendment. I think we all understand the bill. We don't need to drag this out another week. We should, if we like the amendment, we should see if someone seconds it and be done with this issue. Just for the record, I hate the amendment. You might lose me on the bill if we vote this amendment.
Okay. I don't believe that there's any more information that Lorenzo and Rebecca can glean. I mean, I think, we understand what the impact's going to be. I'll ask if anybody wants to second the amendment. If nobody does, yes, Delegate Tolles. You got to take yourself off mute.
Yeah. Get there. Sorry. Can someone just read? You didn't read they didn't say what the amendment actually did they? I missed that. We pulled it up.
Yes, the amendment.
I have it, but I'm saying if Lorenzo needs it, I have it. I'm saying if you want to read it for them.
Delegate Tolles, we don't have it.
That's why I was asking if somebody could just say what the amendment is.
I
can say, but Delegate Embry, do you want?
I can pull it up, but I don't have it on my screen.
It basically.
What, do you want me to? I can. Yeah.
Delegate, yes, it's your bill. Yes.
Thank you. Sure, I appreciate it. Thank you. Right. So it would apply it would allow estates with a known universe of heirs, spouse, partner, lineal descendant, lineal ancestor, allow them to post only on the website and not be subject to the print notice requirement because, again, they are all known.
There's a motion. Is there a second? What's the
Excuse
ruling
me,
of the
I think
chair?
I'm the I think I'm the chair.
The ruling of the
Okay,
chair.
you can talk to the chairman about maybe swapping me out. Is there a second on the amendment? Okay.
Who's favorable?
Yeah, I'll second it. It's look, y'all can vote it up or down. I'll second it. It's fine. I just
All right, good. All right, everybody who is favorable, raise your hands.
I'm sorry, is this was
On the bill, there's a motion.
The bill
favorable
as
on the
okay,
bill.
then favorable.
Bill
Yeah.
originally.
I thought there was a
It's
second
bill
on the
as-
amendment.
Yeah, it's the bill as it's for the amendment.
Oh, I apologize. I withdraw that. I apologize. You seconded the amendment. Great. All those in favor of the amendment? Am I the only one who's in favor of the amendment? Is there anybody else in favor? Two in favor.
I'm in favor because it gives. Can I do discussion?
Yep. Good.
So I think it gives the ability to say only if you don't live in the area that you can do the print. And I think that's okay because heirs do live out of town. They might not live in the immediate area. Am I incorrect? Is that what the amendment does?
Yes, the amendment basically splits the number.
Right.
Essentially splits the number in half, and all the people that they know who the heirs are, and they're very, very close heirs, the spouse, domestic partner,
Right.
children, parents. If those are the only listed interested parties, they don't have to publish because
have
they
to-
know
yeah.
who they are.
Yeah. So it's kind of split it down the middle. I'm okay with that. Yeah.
Okay, so there's three in favor. Yes, Delegate Williams, did you have something
Well,
to say?
I guess it's a question. We're on the amendment, correct?
Mhm.
And I apologize. So how does the bill, I mean, I know the amendment's in her name. I mean, how does the bill sponsor feel about the amendment?
I guess, I mean, I think there's votes for the bill as is, and that's my preference, but if the majority of this group wanted the amendment, I would go along with that.
Okay, thank you.
Okay, hold on one second. So there are three in favor, and how many opposed to the amendment? 1, 2, 3, 4 opposed. That and 5, Schmidt opposed. Okay,
Move favorable on the bill.
there's a second.
Second.
Okay, all those in favor of the bill unamended, raise your hands. 1, 2, 3, 4. 1, 2, 3, 4, 5. 5. All those opposed. Oh, I'm sorry. You were in favor, Delegate Phillips, or did you want to say something?
No. Go ahead.
Okay. All those opposed. I'm going to vote opposed. Okay. Bill passes. Look at that. Congratulations, Delegate Embry.
Thank you, Bill. Thank you all.
Okay.
And I'm sorry to put you in an uncomfortable position.
Oh, that's okay. You're nothing like my kids. My kids put me in a comfortable position every day.
Thank you, Mr. Chair and delegates. We'll see you on the other across the street.
Thank you very much. Okay.
Thank you. Bye.
All right.
Thank you, Mr. Chair.
Yep. Very good job. I think that criminals in like a half an hour.
Okay.